right, welcome consumers. I'm so glad to have you here for the very first video in our Pro video series, the ultimate video series that we have in our consumer individual course. So glad you are here to join us. Again, this course is the most developed, the most depth, comes with templates. We really get into these laws and how consumers can fight back, including with our first topic today, which is the secret power of the FDCPA, how to fight back. As always, I'm your course instructor, attorney Aaron Swift. I'm Swift Law North's CEO and managing partner. Just like with all our videos, we start with an agenda. We're going to talk about the purpose and power of the FDCPA, its major protections, the damages and remedies available, how attorneys' fees and costs are paid, and consumer best practices. Okay, now we talked a lot about the FDCPA and even put emphasis how the first word is fair of the Fair Debt Collection Practices Act. But Congress specifically said it's the purpose of the act to eliminate abusive debt collection practices and to ensure competitive advantages. So with that purpose, it comes a lot of power. So the FDCPA can be and is often used to fight back against collection lawsuits and even to spur a lot of debt forgiveness and trade line deletions. And I've talked about that throughout the series as well. So if you remember, the FDCPA is meant to protect the most gullible, the least sophisticated consumer. And Congress even noted that unlawful debt collection can lead to unnecessary bankruptcies and even divorce. Okay, so what are some of the major protections? We kind of talked about some of the common violations in the last series, but we're going to talk about some major protections, which are kind of the other side of the coin. So it forbids debt collectors, remember the definitions, third-party debt collectors and junk debt buyers from using false, deceptive, unfair, or misleading means, cannot engage in harassment or abuse. It regulates when, where, how, and to whom third parties can communicate, or excuse me, third-party debt collectors can communicate, including to third parties. Debt collectors are not allowed to disclose private information to third parties, whether that be secretaries, assistants, dispatchers, neighbors, relatives, references. If you remember, they can use debt collection efforts to locate a third party, but cannot disclose any information there. If you remember the videos on the 1692 G notice and the verification validation request, the V&V requests. So that protection comes from this law. It requires certain disclosures. It allows the consumer now, after Reg F, and some amendments to dictate inconvenient times, places, and manners for debt collection communications, and also regulates where lawsuits can be filed. Again, see Pro Video 6 for more info, and I've talked about that in the past. So what does it mean if a debt collector or debt buyer violates the statute? The statute has some secret damages and remedies available, and I call it the secret power of this law because so few consumers know anything about it at all, let alone its details. So one of the damages available are statutory damages up to $1,000 per action. So if you file a lawsuit against a debt collector and has 3 different claims, you still can get up to $1,000 only per that action. But that's a great incentive. It's a small penalty in these cases. You can also get actual damages. Actual damages can be in the form of monetary loss. So for example, if a debt collector charged an illegal fee, that can be received back as an actual damage, often in these cases. You can also get non-economic actual damages. That can be emotional distress, anxiety, frustration, things that can be backed up, but don't have to be backed up by doctors. If you're taking additional medication, these situations are stressful, and Congress very specifically allowed actual damages to be collected because debt collectors can cause a lot of damage. One interesting note about this law, it does not provide for punitive damages. On the other hand, it often is used as part of a settlement to get debt forgiveness or debt waiver and then trade line deletion. So I've talked about these several times, but I want to go into this more in detail. I get asked all the time, so how can consumers afford to file these types of lawsuits? How do they afford to hire you? And practically speaking, it's because there's a one-way fee provision. What that means is if we prevail, if the consumer prevails by a jury verdict, a judgment, a settlement, those are the 3 most common. In that instance, the consumer has prevailed. And because the statute says to the prevailing consumer, the other side has to pay their fees, It's basically a one-way provision, and it's one way, which is incredibly important and a secret because not many people understand this, is that even if the consumer loses, you do not pay, not only do you not pay my attorney's fees or the consumer's attorney's fees, you don't pay the other side's fees either. So that is a very powerful tool. And Congress kind of realized if consumers had to hire lawyers and pay, lawyers' expenses during representation, they would never do so under, these circumstances where we're talking about sometimes small debt, sometimes small issue credit reports. But nonetheless, it gives incredible leverage, and we do that with what we call a blended contingency fee retainer. So still the principle that we only get paid if we win is absolutely true. And we're paid either a percentage of the case, and that depends on where in the case it occurs, that percentage and the type of case, or we're paid our hourly rates, whichever is higher. And that's a really powerful tool because it means that if the debt collectors want to fight us for a long time, they're going to have to pay a potentially really big bill for our attorney's fees, your attorney's fees at the end of the case. So as the debt collectors decide to fight, if they decide to fight these cases, they have to pay their attorneys the entire time. And then ultimately, when the consumer prevails, they have to pay my fees and costs as well. That's in addition to the damages we talked about on the previous screen. So you can imagine how that is such incredible leverage when the debt collectors are staring down kind of a double barrel of their own attorney's fees, the consumer's attorney's fees, and of course, all of those just grow as the case goes on. So what are some consumer best practices? I've said this so many times, consumers have rights, and understanding the basics of them provides an advantage when dealing with third-party debt collectors. One of the biggest things you're going to hear a lot, do not bury your head in the sand. If you hear from a debt collector, remember there's only a 30-day verification validation period. There's a lot of powerful tools at your disposal and in your toolkit that we've talked about in these video series that are only available during that first 30-day period. There are, of course, other protections available after that, but if you have an opportunity and you first hear from a debt collector, don't bury your head in the sand. Use some of the protections that are available to you right away. And then I would say, on top of understanding, common violations and now what some of the secret powers are, you can also check debt collection efforts against your credit reports. Everything should be consistent. Check out the video number 7 in this series for more information. But think about how if a debt collection letter is requesting one amount and credit reports are collecting and requesting different amounts, there's a problem there. One or two things are happening. Either they violated the FDCPA by debt collecting an improper amount, or they've potentially violated the FCRA by credit reporting a wrong amount. Both cannot be true. And so there's a lot of opportunities and some, overlapping between these two statutes. And then pro video number 7 is how you can kind of use both. And lastly, I would just wrap this up by saying, if you have issues with third-party debt collectors or junk debt buyers, if now understanding the power of this law kind of is a catalyst to saying, I think there may be some problems here with some violations, please reach out. You may be entitled to significant damages. We've learned about the types of damages here. They are a lot more involved. There's a lot of jury verdicts and amazing cases around the country. We're going to talk about some of those later on in this pro series as well. But again, just reach out. We want to be here to help. That's why we have educational components at consumerlaw101.com. And then if litigation is necessary, and if one of these debt collectors or junk debt buyers have stepped out of line, contact us at swiftlawnnorth.com. Thank you.